07. John Wheeler, Mitchell McNutt. Sam's. Minnie Shelley versus North Mississippi Pain Management. Hi, John. This is Vicki Hoggett. You had written me a letter and asked me to give you a call. Okay. Okay, just a second. I'll put you on speakerphone. Hello, can you hear me?
I can.
Okay, great. Minnie Shelley, I got a letter from you saying that in order to get an itemized statement of charges made by the hospital, that she would have to pay for it.
Yeah, hang on a second. Tara, bring me whatever we have on that Minnie Shelley matter so I can look at it. Hang on just a second. Let me look at that.
Okay. You're not talking to me, are you?
I wasn't. I'm sorry. Let me look at this letter.
Okay, I just don't want to not have to send you an email I hadn't sent you, so.
Yeah, I mean, I think if all you want is a copy of the bill itself, I think we can probably, I don't have a copy. If I did, I'd just send it to you. I can probably just make a copy of the record, the bill itself, and send it to you. The records, as far as her treatment records, if they're de minimis, I mean, that was just, I mean, I always curious, because it is also curious if you've asked for record authorization. Do you want just a record from the ER? Is that all you're after?
No. She was in the hospital for several months.
Yeah, you'll have to pay for those. And whatever they normally charge. I don't have authorization. Just obtain those from the provider and send them to you.
No. But the hospital, it is their ordinary and customary policy to provide those upon the patient's request.
Sure, at their expense.
No. No, for litigation, an attorney, by statute, as you know, is limited by how much hospitals and doctors can charge for copying charges, but the patient themselves has a right to a copy of their itemized bill.
Yeah, but they have to pay for them.
Not according to the hospital. The reason I know that is last year I settled an estate for a lady that was at the hospital, and they sent her all her bills. They didn't charge her for them. I would, you know, it just seems logical to me if you've got a third-party payor that would be the only, how do you say, protection against vast Medicare, Medicaid fraud, because if the patient doesn't have a right to see what's being billed in their behalf, then what's to keep any provider from, and I'm not saying the hospital would do this, but I'm just saying what would keep the hospital from sending in.
Well, if you know what the hospital will do, then perhaps you should send your client out there to try to get a copy of the record. But if they come through my office, I've always been told, and I've always been advised, and I've always sent an invoice with those for those expenses, because they have a third-party provider that actually copies the records that charges the hospital. It's not done free of charge. It's done by a third-party provider that actually charges a fee per page. And we've always passed that along to anyone who wants a copy of the records, particularly when they've made that contact to a lawyer. So I can't help you, Vicki, other than tell you that's what I know.
Right. Well, I agree with you that they can charge for copying files for litigation purposes. And we are lawyers, and so that's what we run into. But the patient themselves, just for your future reference, has a right to request a copy of their bill, and they will not be charged.
No, I don't need that for my future reference, because all I deal with is litigation. So unless I have my own personal record, with which I need a copy, it's of no moment to me. But this is potential litigation. You're looking at a potential claim against the hospital, so I think of no reason why this individual would need a copy
That's right, because she wants to file a lawsuit. I do not want to file a lawsuit. To me, this is something that can be discovered in good faith, and
they can't say. I think that's where you misunderstand, and I know you don't litigate a lot of cases based on your letterhead, but I do. I was 20 years litigating cases, defending medical cases, premises cases, and other cases throughout the courts in Mississippi and other jurisdictions, and we can't discover anything unless litigation is pending. We can't take depositions. We can't engage in inspections. We can't exchange documents. None of that's going to take place unless we have the protections of Rule 26 through 37 of the Rules of Procedure, which are the discovery rules. So I don't know what I can do. I mean, I can attempt. Certainly, we have resolved cases in the past without litigation. If there's some proposal you have to get this resolved, you can pass it along to me. I'm certainly ethically bound to do that. Pass it along to the hospital, which is self-insured, and they may have some interest. I don't know. I don't know anything about your client's prospective claim other than what you've told me.
okay. The letter said to call you and make an arrangement to. She was there for me to come, and she was there being treated, and so she was going to show me what happened at the door, because the insurance adjuster, now self-insured, what is MHA Solutions?
It's the same thing. It's Healthcare Providers Insurance Company is actually a first-party insurer. Healthcare Solutions is the TPA.
Okay, so can I get a declaration of insurance from you?
There is none. We're self-insured for these claims.
Okay, so there is no med pay without fault?
No.
Okay. All right, so we need to set up a time that no one will be objecting or overseeing or eavesdropping, that the client can go and show me what she did, what happened.
Yeah, I don't know that they're going to be agreeable to doing that, Vicki. The reason I asked you to call me was so you could give me some parameters on what it is you desire to do.
I just want to go see the door. The Shay Moody, who says he was the claims consultant for this MHA Solutions, had this scheme in his mind that he told me this is what happened, even though he says there were no eyewitnesses. And Mrs. Shelley says, no, that is not what happened. And so he said, go out there and see for yourself that this could not have happened the way she's saying. So that's what I wanted to do. And that's what I still want to do, because this claim to me is, Shay Moody told me he would get me the name and model and make of the door, so that I can find out if they're similarly situated plaintiffs, if this is something that happens. And it's true, you know, but I don't want to. What I feel like is she's being forced into a position to file a lawsuit. And that's, you know, it is the position of the courts of the state of Mississippi, including the Mississippi Supreme Court, to early resolution of conflict. And this isn't even a conflict.
That's up to the parties. I mean, it certainly has to be an amicable situation where everyone's agreeable to resolution. Right. Certainly no forced resolution takes place.
No.
So, I mean, I don't know. I'm not trying to be difficult with you. I just don't have an answer for you.
Okay, well, you're the one who wrote me the letter and said, set up a time. So
I didn't say set up a time. I'm reading my letter.
What does it say?
You need to read it again. It doesn't say anything about that. It says to call me to discuss your request for an inspection and to identify some potential parameters for that so that I can ask my client as to whether or not they want to agree to that. Okay. That's what my letter reads. I'm looking at it right now. It's written August 22, so you've misread it or misunderstood, and I apologize for both. But no, I didn't say anything in there about calling me to set up a time. It's not written in there. And that's not what it says. That's not what's going to happen.
Okay, parameters.
I know you know the rules about ex parte communication. You're not to have ex parte contact with any current employee of the medical center in light of the fact that I represent an institution in this claim. And, you know, as to whether or not you decide to go out and attempt some sort of inspection on your own, I mean, that would be up to you, and you can make that judgment. But if you do, you run the risk of the property.
John, I'm calling you in response to your letter to set up some parameters. So, if you would kindly ask your client